With the consent of other side, I beg to mention item number 24, Lordship. We are appealing for respondent Oil India Limited, Lordship. Lordship, may grant us 3 weeks time for filing our affidavit in court.
You appear for 2 and 3.
1, Lordship.
Let it be called out. Because 2 and 3 are unsolved, so we'll have to ask them to take steps.
I am for the appeal of the lot. Question number 3, the T has been served the lot.
Then you file affidavit.
Still filing the affidavit.
Officer report, and what about this phone number 2?
Question number 3, as per my information, he is an officer of the Oil India Limited.
He has already retired, Lordship.
Therefore, either you can delete him.
Yes, the lot.
We will not pass that order today, but then we don't ask you to take any step.
Yes, the lot.
Next.
May I please, Your Lordship? With regard to item number 33, my lord, I am for the appellant, my lord. By the previous order dated 21/7/22, the newly pleaded respondent was directed to bring the records, my lord. I am told that the records are available today. The Lordship will permit us to peruse the record and take up the matter after 2 or 3 weeks, my lord. Anything.
Next.
May I please, Lordship? On item number 30, my lord, I am appealing on behalf of Mr. SS, my lord. I have taken the concern of the other side, my lord. Please, dear, my lord. It may be taken up in the next 2 minutes. During the course of the day, my lord, we are going to file the affidavit, my lord.
Item number 30.
13, my lord.
1-3 or 3?
1-3, my lord.
Oh, 1-3. Affidavit is there. Higher to continue.
Yes, my lord.
Higher is there, that will continue.
Yes, my lord. There is an intent, my lord. That may be-
You are for the appellant.
May it please your lordship. Lordship, from item number 35 to 37, lordship, I pray for adjournment for 2 weeks, lordship, to enable us to file an affidavit in opposition. Your lord.
Lordship, in item number 36, the same matter, your lordship, there is an interim order, your lordship, may that continue. Obliged.
My lord, I beg to mention item number 16 of daily list. My lord, the matter may be taken after 2 weeks. My lord, we have to file implement petition.
What is the contempt? Elite contempt?
So promotion matter, my lord. Promotion matter.
No, have they acted upon the direction of the division bench?
I don't know, my lord. I am not aware.
You should know when you are the petitioner. Will not adjourn it. Unnecessarily contempt are thinking courts on wait till the matter is called up. I inform Mr. Chaudhary if you informed him that you are asking for time. Yes.
May please, your lordship. Lordship, with the due consent of the other side, I beg to mention item number 11 of the daily list, your lordship. Lordship, I have taken the consent, your lordship. This matter, Mr. P. Nayak is appearing, your lordship. Today, some personal difficulty he has. Can this matter be fixed after 2 weeks, your
Who appears for the government?
lordship? Mr. P. Nayak, your lordship. He's today some.
I am appealing for the appellant, my lord. My lord. Few occasions time has been taken, my lord. I don't have objection, but let them expedite the proceeding, my lord.
My lord, will be we are supposed to file an affidavit, lordship. We'll be filing it shortly, lordship. Today, some personal difficulty.
Ask him to deal with the main aspect involved in the petition. The other respondent has filed the affidavit in form of the pair-wise remarks that he has received from the department. No comments and all that are there in a virus matter. You have to file a detailed affidavit. Next.
May it please your lordship. Lordship, I am praying for listing of 2 writ appeals, lordship, on either on 23rd or 24th of this month.
23rd you are mentioning on 5th. Mr. Chaudhary is again going to Supreme Court or what? If you are asking for 23rd, give the list, even otherwise it will come.
May it please your lordship. Lordship, with the consent of the other side, I beg to mention item number 6, lordship. This matter may kindly be taken up after 2 weeks, lordship.
Service is not complete. Wait till it's called out. Please wait.
My lord, with the consent from the other side, I beg to mention item number 4 and 5. These matters may be kindly adjourned for today, my lord, as my senior has some personal difficulties. The matter may kindly taken up after 3 weeks, my lord.
Next.
Item number 1 of daily list for motion.
Please, your lordship, my lord, the petitioner has challenged the action of the authority proposing to construct a cruise pond, converting old grazing field, my lord. And thereby the people will be deprived of feeding the cattle, and it will badly affect the rural economy. As well as my lord, that these are partly also used for cultural activities, religious activities, and sports. That will totally stop. The area is not a dry area having sufficient irrigation schemes, my lord.
But I fail to understand one aspect, Mr. Counsel. On one end, you say that it is to be protected as a pond, means a water board.
No, your
No, no, no.
Listen, there is an environment, therefore I am saying. On other end, you say that it is a cricket ground.
It's a grazing field, my lord.
That is what I am saying. On one end, you say it's a grazing ground.
My lord.
On other end, you also say that it is used for playing cricket.
yes.
My lord, partly used, my lord.
And then we don't know what is what.
My lord,
Whenever you approach the government,
it should remain as a grazing field, my lord. The local people,
whenever you approach the government,
my lord, we have approached the authority, my lord, by submitting representation annexer 4, my lord. Annexer 4, page 24.
so it is the date of.
My lord, it is 11/8/2022.
We will direct the government to decide this.
My lord.
Before within a stipulated time.
My lord. My lord.
Called Mr. Speaker. Okay, appellant that so advance of yeah. Petitioner posing to be a public spirited citizen. The shortly for us. By way of this petition, to whether and in question, fact number 370, Sir Ujai Revenue Service can be used for purpose of creation of a pond under the Amrit Sarovar scheme or
Right.
not. Find that the petitioner along with other persons have approached the authorities by or the different authorities by way of the present date dated point 824 11/8/2020. We find that the state representation is addressed to Deputy Commissioner of Ujai District, Pankaj Dev Nagar, Ujai, Assam. Petitioner shall file a further detailed representation to the Secretary Revenue. Revenue Secretary,
Commissioner and Secretary.
Huh?
Commissioner and Secretary.
Commissioner and Secretary, Revenue Department, State of Assam, State of 1 of state. Secretary and Commissioner, Revenue Department, Assam is hereby directed to consider presentation that may be filed by along with the application dated 8/7/8/2022 filed by the petitioner before. So in accordance with law as that is possible, not later than 2 weeks from the date of the receipt of such representation. It however verified that no personal relationship has been and Secretary and Commissioner shall communicate the order to the petitioner on the address mentioned in the petition. With this observation, the petitioner is disposed of at this.
Deep love, like that.
Actually, may I pray for 4 weeks time?
Item number 2,
You take a copy of this and give it to learned advocate.
Yes.
We are keeping it on next Monday.
Yes.
Even if the state is not a party, we want the real public. Take the copy, in fact, we wanted this, but not back of it. Context, next,
Item number 3,
7, sir.
My lord, here I am the my lord with a very limited prayer, my lord. So there a proclamation of sale is my lord announced on 22/8/2022 for depositing the my lord earnest money on fixing today and the opening of the tender on my lord 11th of this month. So my lord, here earlier two occasions my lord they have issued a proclamation in one 2016 as well as 2017. In the older times my lord, nobody turned up to take the participation of this auction sale. So my lord, this petitioner is there all the my lord cooperative societies registered under the Societies Act, and because of the certain my lord facts which are unavoidable, they could not make the my lord pace of the payment at the time. So they my lord that was declared as a my lord non-performing asset, and accordingly my lord way has passed. The certificate amount is 36,75,076.
Now, counsel, when that when that was done,
My lord,
when that order was passed,
that was my lord passed on 19/7/2022. DRT, and accordingly, well, a proclamation of sale was announced on 22/8/2022, my lord. This is Annex 7 at my petition, my lord.
Yes.
So my prayer is this, my lord, is since the bank is already, my lord, failing target 2 occasion. So we are trying to mobilize the fund. So we need maximum, my lord, 3 months time,
not
So
even
that-
3 minutes, Mr. Counsel,
my lord.
not even 3 minutes. We are not here to reconcile, as reconciliation.
My lord, there is a my lord, attempt was made, 5 lakhs was deposited, still lying with
Neither
them.
you are not there.
But that was my lord failed. So
No.
my lord, only my lord 3 months time. We are if we are failed, then they go for action, my lord. Because the bank will be benefited in our proposal, my lord.
If you want, you can bid in the, you can bid.
No, I will give my lord only 3
No,
months.
you be a bidder. What is this? All, nothing doing.
My lord, it is a cooperative property, my lord. This is not that
Whatever it
individual
may be,
property. 100
cooperative or-
more than
or you-
thousands members are there.
Mr. Counsel, when you went to
My lord,
take,
Mohanta, my lord.
when you take loan, you forget everything. You even I
No,
would
my lord,
blindly
my
say.
lord, this time also every
Since
possibility
2010.
nobody will turn up, my lord. Well, kindly
Mr.
see,
Sharma,
since 2017, and moreover, kindly see the order that is passed by the my lord 19/7. This is my lord, Annex 6, my lord, where it is specifically, my lord, that auction was at their risks because the property is under the my lord, occupancy of
Mr.
the tenant.
Counsel, turn to page 25.
Yes, my lord.
It is order dated 18/3/2014.
My lord, we made an attempt, my lord.
Array, you listen to us for now. We were issue recovery certificate of 36 lakhs. That happened in 2014.
No. We are not on that, my lord.
No, we are on that. If you are not on that,
No, the present value, my lord, they have, my lord, they annex the valuation certificate that is more than the reserve price. 76 lakhs now they reserve the
you
price. in property is
have
80
no
lakhs.
locus to challenge all this now.
My lord, I am ready to pay, only 3 months time is given, my lord.
Then go there to the bank. We are not here to guide them.
My lord, only my lord, that liberty is given, my lord, to approach, my lord.
No liberty. You don't lead. We have not stopped you. Where is the question of?
No, we are not
Standing
stopping,
with
but the my lord, property only the to
These
for
are
a
all,
stall for a moment, my lord. Stall for a month for 3 months. It is
nothing
not
doing.
nothing
These
much
are all
more than time we are
necessary
saying.
things, your money, my money, money of
That
videos.
is why, my lord, we are trying, my lord. We are trying best. That is why I, my lord, humbly prayed, my lord, before our at least 3 months, my lord. We are not going for the complete stall of the
I told you at the outset, not even 3 minutes.
my lord.
As soon as you complete, the order will be over within 3 minutes. Nothing doing.
I could not follow, my lord.
We are not inclined.
My lord, kindly see one thing, my lord. The earlier attempt was made, 5 lakhs was deposited,
On the
and that was
contrary,
fake.
on the contrary, your Learned Counsel, probably your petition also is defective. Now, UCO Bank does not exist in eye of law.
My lord, they are performing as a eco bank, my lord.
But I am just telling you.
It is, my
Bank
lord,
of
they,
Baroda.
amalgamation is there, but still they are performing as a eco bank. Eco bank merged, but other bank merged with the eco bank, but the eco bank is not merged with the others, my lord.
Whatever it may be, we are not.
That is the true, my lord.
Hurt Mr. Panta.
Their bank will be benefited. I from the bank will not object this thing. my lord.
They don't, even if they don't object, we object to it. You
My
are,
lord,
you
if
are,
the
you are
bank-
asking us to exercise
My lord,
our jurisdiction under 226.
My lord, this is a
226 is-
limited, this is why I come before lordship with a limited chair,
226
my
is
lord.
not
This is
meant for persons like the petitioner. When they try to sit on the fence,
My lord, two occasions they have already failed, my lord. None is turned up. That is why I am before lordship.
when,
That
when
this
did-
time also maybe
did
happened the
you,
same
did you
thing.
approach the bank after that?
Yes, my
Ever?
lord, I have approached many times, my lord.
Many a time.
And the
Everything
5 lakhs are
over.
already deposited with them. This is lying with them, my lord.
Anything else?
That is my submission, my lord. That is up to your
All
lordship.
the-
If I am not able to satisfy my lord, this
These ones
is
are for
this
the
portion, my lord.
petitioner and Mr. M. Sharma. On it, copy and clear of the respondent side. By way of this petition under Article 226 of the Constitution of India, the petitioner is paid for the following. Mr. Manta, learned counsel appearing for the petitioner contended that the petitioner has shown willingness to pay the debt for which 3 months' time be granted. It is quite clear from the factual matter which can be culled out from the record of the petition. It appears that the petitioner has come on the eve of the property being, mortgage property being put to auction only because twice the auction proceedings have not culminated in any recovery. The petitioner as the principal borrower does not get any inherent right to throttle the same by filing such petition. Even the contention raised by Mr. Manta that the petitioner intends to pay appears to be far from truth from the very conduct of the petition. We do not find any reason to interfere with the recovery proceedings initiated by the bank. Almost after 8 years of the passing of the judgment by PRT in the year 2004. No case for interference is made out. We don't find that this case is a fit case to exercise our extraordinary jurisdiction under Article 226 of the Constitution of India. The petition fails and is hereby dismissed. Next.
My lord, with all respect submitted, my lord, the secretary who was suffering for a kidney transplant, that is was the reason, my lord, they could not come in earlier, my lord.
Item number
I
6.
have annexed all
for
the
admission.
documents, my lord. Now, submit.
Item number. Service is not complete.
My lord,
the
the extra copies we have served, my lord. Extra copies have been served.
Lordship, let the matter be admitted and fixed for in hearing, Lordship.
No, but the office report says that it is not complete.
All the government, my lord.
All are government.
Yes, ma'am. The
Five.
Did you file any affidavit in? Did you file affidavit before the learned single judge?
yes, Lord.
Do you wish to file any affidavit here?
No, Lord.
No. Then
Obliged, Lord.
submit for hearing.
Item number 7.
Lordship, may I read the matter passed over time being?
Lordship, here, we were supposed to file an affidavit. I have sent it for vetting. Lordship, may take it up next week, Lordship.
2, 3. Next.
Item number 8.
May I please? My lord, matter is to the Gaon Panchayat, no confidence motion, my lord. My lord, the facts of the case is like this, my lord. There are 10 ward members of the Gaon Panchayat along with the president. President is correct. They filed a requisition for no confidence motion on 17/6/2020, my lord. And on the basis of requisition for no confidence motion, the no confidence motion was held initially
right. You turn to page 164.
Yes.
Last three lines. Last three lines.
Yes, my lord.
Please read that.
Yes, sir. My lord, on that one, can clarify only one
No,
thing.
no, don't
Yes,
clarify. You have no right to clarify.
Yes, my lord.
You can run away from the statement
Not
made
yet.
before the learned single judge.
No, that,
Please read that as it is.
Mr. I should the Learned Council for the paper submit that the secretary of the Gaon Panchayat is the respondent number 4 has rightly forwarded a requisition to the respondent number 2 since Anchalik Panchayat had failed to take action in the matter. Mr. Chaudhary has however submitted that in his usual fairness the prescription of law has not been followed into the by the respondent number 2 while
Now
containing.
you have made a statement. Only by change of counsel you can change the stand.
No, I'm not changing. Only
Now,
one
you
thing.
are changing. You have agreed before the learned single judge.
No,
You make this single judge to pass a particular order on your statement, and now you are challenging before the division bench.
no, only one thing I have to clarify.
File review before the learned single judge if you find that this statement is made without authority.
Ah.
You will not entertain such frivolous appeal
No,
of change of stand because of change of other situation.
no,
It can't be done, counsel.
my lord,
You concede before the learned single judge, and then you take the same plea before the learned division bench.
no, I admitted, my lord, one thing I admitted that the meeting was
Are
not
you
held.
Mr. Chaudhary?
Yes, my lord.
You are Mr.
Yes,
Chaudhary. Then
I-
you can't allow. You should not have. Should have advised your client that I have made a statement. Go before the learned single judge and tell him that I have wrongly made this statement. Why should we entertain the appeal based on almost a consent order? You consider.
No, only one thing I pointed out, my lord. Only I might be submitted. Only one minute. My lord, actually, my lord, the DC after getting
We are
the
not on DC or anybody. It is your statement. And the learned single judge has been kind enough to say in his usual fairness. Therefore, you are known for that usual fairness.
yes, that
You
is
want
why
to be unfair before the division bench and very fair before the learned single judge. With greatest respect. You can't have the cake and eat it. This practice is not proper, Mr. Chaudhary. You say something before the learned single judge, then you have some repentance or some instructions that no, you have made. You can't just challenge it. Even if other counsel would have been there, we would have told him the same thing. The statement made on behalf of the client. On basis of which the learned single judge go further. They have no objection if the impugned resolution is set aside. It's not that you have made only one. Your usual fairness has continued. Therefore, if times it happens, Mr. Chaudhary, that because of some communication gap or something, statement is made, go before the learned single judge and point out by way of a review that it was complicated.
but
Otherwise, what you intend to argue that DC and 15 is not properly followed.
then I give me when the liberty then, my lord.
But is always there.
Let me point it out.
Told Mr. I Chaudhary.
I'm on the refer number 1.
Not a- that- that- that file. But you have the answer that it was made. But that description of the statement made, the description of law has not been followed. By conveying the meeting dated 29/10/2020. Either proper or erroneously made. Present appeal is not pressed at this stage. Appeal stands dispose of the aforesaid record. Next,
Item number 9.
Wait, please, Lordship. Maybe in this case, Lordship, affidavit,
Lordship,
I will
here,
do my-
Lordship, we will be filing our affidavit. Lordship, let it come after 10 days.
Lordship, you
Lordship.
two times, three times, Lordship. Lordship, status quo should be maintained, Lordship, but otherwise it will be infectious, Lordship.
next,
Lordship,
it is
infectious,
just
Lordship. Right.
2 weeks.
Okay, obliged.
Item number 10.
Your lordship, I appear on behalf of respondent number 7, your lordship. I paid a matter pass over a time being, your lord.
2 o'clock.
Like,
Next. Oh, sorry. Today we have got a full bench. Mr. Chaudhary, we have a full bench at 2 o'clock. So let it come next week.
lordship, today itself, lordship. at the end
Let
of
it
the-
come next week. Because we have a full bench at 4.
My lord, in fact, in this matter, my prayer is only to examine it. I am not praying for any interim order today, my lord. Your lordship may issue notice. And also, my lord,
No,
on the
all are appearing, guys.
my lord.
All are appearing. Mr. Sir.
Yes.
So notice may not be necessary at all. Let it come next.
Item number 12.
Me, please, Lord. My lord, in this matter, I am appealing for Mr. Nair. My lord, we have received the instruction, my lord. We pray 3 weeks time for filing the affidavit. my lord.
Next.
Deeply obliged.
Item number 14.
Please, my lord.
Service is not complete.
My lord, perhaps the service notice is still awaited.
That's what we are saying.
Yeah.
Give it to-
Obliged, my lord.
Item number 15.
My lord. My lord, in this matter, my lord, the director of municipal administration, he requested me to stop for some time because the person who is in my lord ICU, my lord, entire file is under lock and key. He said, director said, my lord.
2 weeks.
My lord, deeply obliged.
Item number 16.
In this case, my lord, implementation petition is ready, my lord. If you want the endorsement, my lord, I am working, my lord, on the petitioner.
Mr. Chaudhary, what is the position?
Lordship, in this matter, Lordship, the necessary steps have now to be taken by the state, Lordship. So far as the respondent number 1, I am appealing for the respondent number 1.
No, we have looked at your affidavit, therefore we did not extend the matter.
Yes, Lordship. I do not know whether necessary action has been taken by.
Bhattacharya, what have you done? That is why we wanted time, we said, let it be called up, so that we can test out the matter.
Yes, Lordship. Already, I think
Somebody has to appear. How much time do you want?
we need to take. Lordship, I'll furnish a copy of my.
Please
affidavit
furnish
to
it. That is why we
Yes,
wanted
Lordship.
somebody to appear on.
Yes,
behalf.
please, Lordship.
Item number 17.
Lordship, this divisional forest officer supposed to file affidavit.
Who appear? Pathak?
Pathak.
Mr. Bora?
Lordship, the forest department has to file the affidavit, Lordship, regarding that.
Mr. Pathak would be appearing?
Yes, Lordship, but
Yesterday
Lordship,
somebody
may
told me
kindly
he
take
was
it out
absent.
on Monday, Lordship, because I,
Let it come on Monday. At least we can
Lordship.
pass an order for
Lord,
filing affidavit. Next. Seven.
I shall inform.
Letter number 18.
Lordship, it relates to the payment of back wages, Lordship. Lordship, pleadings are complete, so it may be fixed for hearing, Lordship.
Lordship, the structure. Petitioner is affected. Yes, here said,
TRC in Lordship.
here said for specific. Keep that up. Hearing.
Lordship, I pray that a date may be given,
Please
Lordship.
not to permit us to complete. To come upon. Fifth of September. Next. Second to fifth December. Next.
Letter number 19.
Deeply obliged, Lordship.
The Lordship, we have filed the affidavit to the we have filed a rejoinder affidavit to the affidavit filed by the State of Assam as well as Union of India, Your Lordship. Those are on record.
It is in form of additional affidavit.
One additional affidavit has also been filed and the rejoinder affidavit to the counter affidavit has also been filed.
It is a Lordship kindly fixed for hearing.
Every matter we can. Admit for here.
Next.
Deeply obliged. Letter number 20.
May I please, Your Lordship? My lord, in this matrimonial appeal, the appellant, my lord, has challenged my lord one expert judgment and degree,
But
judgment and order, whoever my lord, the suit of the appellant was dismissed, my
respondent is
lord.
not out from it.
Lordship, during the, my lord, the family court proceeding also, my lord, during proceeding of the suit before the learned family court, the respondent did not turn up after due service of notice.
Here that service is not complete. Counsel
All right, my lord.
to await service.
No.
Next.
All right.
Letter number 21.
May it please, Your Lordship. As per office tool dated 23/9/2022, respondent was 6 and 7 awaiting by awaiting by.
To await service for respondent number 6 and 7.
Letter number 22.
Please, your Lord.
Yes,
This petition is directed again for review.
that wrong statement was made.
Yes, Lord.
860.
Yes. Lord. Now the affidavit.
You are for the respondent.
Lord.
Now go to the order. Order pathway. So we will have to recall this order. Will pass appropriate order. Word. Start. Each order. For order.
Letter number 23.
Not too bad.
For 21st. 21st.
Not too
Union of India.
Next.
May I please your lordships, with an apology to this honorable court and apology to all the respective learned counsels present in this case, I pray to correct an order dated 31st October. Here, I by mistake wrote that I'm present for respondent number 1, but actually it should have been for the respondent number 2.
In IA, it is
And yes, your lordship. IA number is 3094 of 2015.
that bit correct.
That is-
In 3094, it is there.
Yes, your lordships. My name on behalf of SK Media should have been appeared for respondent number 2. But by my mistake, I wrote that I am present on behalf of respondent number 1. Your lordship, respondent number 1 is a private party in
So
this
you
case.
appear for union of it.
Yes, your lord, on behalf of SK Media.
That we will have to issue notice to respond.
Yes, your lord.
My lord, I have taken steps as per order on respondent number 1
You served it.
by by register postmark. As per order, my lord.
No, but
Your lordship directed to take steps on respondent number 1 by register post and other was to serve copy. I serve copy also.
that office report is not there. Office report says 2, 3, 4, 5 and 6 have been received.
Yes.
Acceptance of notice. So even if we don't correct this order, there is no difficulty. You have already served it.
Serve them.
So we await service of respond number 1.
Yes, ma'am.
In the order dated 31/10/2020
Yes, in order to go.
inadvertent.
Actually, my lord, case is fixed on 9,
No, no,
9/12, 9/12/2022.
we know that we mentioned, therefore it is listed.
My lord, yes,
For
but my
correct-
learned friend submitted, my lord, this wrong case has been mentioned, but his case is already
are-
fixed
are
on
not,
9/12.
Actually appears for Union of India. Not to put. Mr. State Learned Council appearing for the applicant at this stage states that justice service has already been. Any steps are taken to serve respond number 1 with the private party. To come up on 9.
I am appearing on behalf of respondent 3 and 4.
You can
No, here, my lord, my submission is this way. This particular national, here 3 and 4 is made National Highway Authority of India is part. But that particular area, Jorhat area, National Highway Authority is not constructing it. That is the authority NHIDCL, my lord. If until now NHIDCL comes, furthermore also it will be, NHA has not constructed.
you give those details to Mr. State so you can make an appropriate amendment.
By next day, I'll give them. Or by way of
To
affidavit.
come up on 9/11, 9/11,
9/12, my
9/12. Next.
My lord, on respondent number 1, my lord, by register post, not
That
by
is why we
posting.
have stated that steps are taken. We have corrected ourselves. We have stated steps taken. We have not mentioned Dusty, that is removed.
Oblige, lord.
Next,
Deeply obliged, your lordship.
Number 25.
here respond number 3 probably is not served. Okay, respond number 3 is not served.
Lordship, they have given the copy, actually, there is a standing council. Yesterday.
So you are appearing.
Yes, Lordship. I mean, no, Lord. The causes is reflected, Lordship.
You have received the copy of the memo.
No, Lordship, actually, there is already a standing council. They should have given the copy before filing, Lordship.
We have already served, Joseph. We have that.
Recently, only on 30, on 10, they have filed.
Whatever it may be, you don't quarrel on this. You are appearing, you take instructions from your client.
Not
2 weeks.
Oblige, Lordship.
Next.
Matter number 26.
Meanwhile, file your appearance.
Lordship, Lordship. Okay. I'm filing my appearance. My name may be reflected in the cause list. Lordship,
Give the name. Name of so and so may be reflected for respond number 3.
as SCFDC.
So respond number 3 जो है वही है. Who is for the petitioner? He is to come virtually.
My lord, I appear for the petitioner, my lord. I have requested a virtual video conferencing link, my lord.
Yes.
Am I audible, your lordship?
Yes, you are audible.
My lord,
What about service to the private respondent?
Lordship,
my
before
lord, we have already served the private respondent in compliance with my lord's order, your lordship. The affidavit of service is already on my already
No,
in
no, office report says that other respondents are no steps are taken.
My lord, we have already filed an affidavit of service, your
No, no,
lordship. that-
affidavit in service is on behalf of respondent number 5 has been received and the same is placed on record.
My lord, we have filed an affidavit of service wherein your lordship, we have, in accordance with my lord's orders, your lordship, we have published newspaper publication, and that publication
That
is also,
affidavit is not on record, Ms. Banerjee.
my lord.
It is not on record. You have to file that on record. The
Lordship.
affidavit of service by publication.
My lord, I will file that by next date. I'll file that on
Yes,
record.
Mr.
because-
Kalita.
Lordship, some developments have happened in this matter. Let's see what has happened is that like, in this matter, the judgment of the single judge was challenged. In fact, Lordship, state of Mizoram, they have also filed an appeal in the Aizawl bench, and that matter was heard, and interim order was passed staying this order, judgment and order of a single judge. So Lordship, I mean, this is a connected matter, same issues involved. So in my opinion, Lordship, since the stay order already has been passed in that matter, so this matter may be also heard there together, maybe. This is only my opinion, your Lordship. Lordship may have a call on this. Because already a stay order has been passed. The copies are here with me, Lordship.
Counsel, you appear for?
Lordship, I am for respondent number 5.
Okay.
I slightly object to the prayer of activity because I was there in the writ petition and that took more than 12 years for disposal at the Aizawl bench. The reason being, most of the judges who are sitting in the honorable judges sitting in the Aizawl bench, they are party to this case. Rather, I will pray that writ appeal filed at Aizawl bench may be brought here and tacked together. Otherwise, it will never get disposed. It took 12 years for.
This
And
matter was.
moreover, Nipco, your lordship is not a necessary party here. Because I have acquired the land 43880 hectares for the construction of the project. On the clear understanding with the state of Mizoram that the entire land in question is a reserve forest. We have a MOU with, and from the central government, we got a clearance of constructing the project. Our project is going on there, and we have paid deforestation compensation to the state of Mizoram. We have been dragged in this case for nothing. And so far this area is concerned, over which my project is there, that cannot be effected now. And there are 2 judicial pronouncements.
Let the affidavit come in this matter, then we'll look into it.
My lord, if I may submit, the matter was before the Aizawl bench at first, and thereafter the Aizawl bench transferred the judges recused themselves, and the Aizawl bench transferred the matter to your lordship's manner. So it was already before the Aizawl bench.
You take it that I am more aware than any of you on fact or transfer. I can assure you that.
Rather, your lordship, that the ideal case should be brought here.
That is what I am telling learned counsel, that personally I am more aware than any of you because I have to deal with it on administrative side also.
Yes, Lord.
Lordship,
So leave it to me.
Lord, so I don't know.
give us a date, your lordship. because
But
I'm outside.
provided they file the affidavit.
Yes,
You file affidavit, ma'am.
My lord.
5th of December.
Deeply
December.
5th of December.
5th of
December.
deeply obliged, my lord.
Is it convenient to you because you come from outside, you can
Highly obliged, Lord.
Yes,
You are
yes,
from
my lord.
Shillong only, I am told by.
I am from Shillong. I was set up with this case for 12 years. 40 single.
Obliged.
Your sentiments are eloquent, counsel.
Item number 27 to 29.
May it please your lordship, I am led by Mr. Ken Chaudhary, who's just completed the matter and is on the way, lordship. I may be accommodated for 2 or 3 items, lordship, he'll be here. Deeply obliged.
Next.
Item number 30.
You have sought the other side.
Lordship, Union of India, Lord.
You have sought them.
Lordship, yes, sir.
You have sought them.
Yes, sir.
Chile Pondo.
Obliged.
Mention
Obliged.
the judgment of 87.
Item number 31.
Hearing.
Lordship,
Yes,
for
Mr.
senior
Saraf.
counsel, sir, here, AGV is appearing, Lordship. He is on legs in court number 4. Let the other side make start, Lordship.
Yes, Dr. Sir.
Well, the petitioner in this case is challenging the constitutional validity of one amendment made, my lord, in the Assam VAT Act, which you'll also find at page 21,
No, before you start, please wait.
my lord.
See. You appear for the government.
Yes.
So your affidavit is there. We are just, this is not our concern, but you have not dealt with the main question which is raised by Dr. Saraf in this matter. We are just indicating it. After he begins, because these are virus matters, you have to answer it in a proper manner. Because this is now for a limited period, Dr. Saraf.
My lord.
In view of the other
GST, my
developments.
lord, from 177 to the.
Last time also we had made it clear when Dr. Saraf was not there, whoever was there on your.
So the issue, my lord, the short issue is that, my lord, whether the discount which he allowed after the issuance of the invoice.
Trade discount.
My lord, my lord.
Trade discount.
My lord.
Trade discount, and that too also for a very limited period. Now that the new act.
2017, my lord, prior to
Now
that.
new regime has taken over, so it is only for a short period.
My lord.
Though you have dealt with Article 366 part, but please look at your affidavit. Even Dr. Saraf would agree. Therefore, he has not filed any reply.
Lordship, we have got a reply, Lordship.
Who?
By the petitioner.
That he has dealt with that
Yes,
in his reply. That is what we are telling
Yes.
you. Because your affidavit doesn't deal with it. That is the difficulty.
Yes, Lordship.
And he has more elaborately dealt with in his reply, even taking Article 366, which otherwise he has not averred in the petition.
Lordship, then
Because then it becomes difficult for the court to decide on its own.
Lordship, then allow us some time, then we'll
You
try
look
to
into it. More particularly, I'll tell you what I am referring. There are 8 onwards of his reply. Probably it is part of judgment of other high court, which is converted into reply. From the text I could make out.
There is a decision of Jharkhand High Court Directive Division Bench whereby the single provision amendment was struck down.
I have made that research, therefore I know it. Because then I found that the language is exactly, you have lifted it from that judgment. Means your colleagues must have done it. It is available in India Kanun. Therefore, I could read the text, but I could not retrieve the copy because that was
Generally, we don't give the citations because it is for the side to find out.
international is well known. Thereafter, it is diluted also, but that apart you have to deal with it. It is difficult for the court to decide the virus simplicity. Maybe a point of law, but he in his reply we are indicating if you don't want to file it is your. We are bound to hear learned advocate general and Dr. Saraf.
Lordship, then allow me a short time, Lordship. I will try to bring it on to a
If you want to, we are not passing any order. We are just indicating to you what we have marked from the matter. Otherwise, we would not have told you. Yesterday we had additional time, so we have gone through the matter. The court premise it on because it is exactly wordings of the division bench.
So if you also permit me without time, the
One compilation is already there, Dr. Saraf.
judgment comparison, I think, Lord,
It is there. State of your Gannon Turkey.
My Lord, it starts from Kendall.
Then we have that.
But I thought it was not there, sir, prepared.
No. In fact, that is
Then I can give the other side a copy, that will be better.
that we have a better bound copy. You have it. But Gannon was thereafter slightly diluted.
No, the definition only of the sale, that what is the sale, that was starting, that because ultimately it is the sale and the sale price. The sale price will be the taxable, whether it will form part of the sale price or not. That's the question. So it starts from that's why I've given that how it has developed.
Now I was just thinking aloud. It is for my academic purpose. I was that what is the position of the same point under the income tax act? Whether trade discount would be part of the income or not.
So trade discount generally from the turnover, because income tax there is no question at all. When the turnover is there, if it is not allowed, then the gross value is taken because it will ultimately the income which will be there.
No, but the income that you derive ultimately is reduced because of trade discount.
No, income in the income tax act, not the whatever the income tax the return will be prepared by the under the GST or something. The total turnover on that basis of that gross income and the net income will be determined. Now, if as per the act it is not allowable, then it will be treated to be from the value only. The gross income will be determined. Income tax act will not deal with,
is it allowable under the income tax?
No, income tax act will not deal with that whether it is allowable under the sales tax act or not.
No, not on that. Because ultimately it amounts to your income also.
Well, okay, very correct. Income tax act, when the deduction is allowed, it is on the basis of the balance sheet of the gross trading account which is prepared.
So it would be a general thing, not transaction.
My lord.
I was just comparing it with.
Otherwise, what will happen, that Supreme Court decision that the incentive discount when the somebody in the year, they all become the
redundant. Let us see. Next.
You lost me fix a date, this is 2016 matters. So
we'll fix it.
We can. Lordship may fix it on any date after 16, Lordship.
We are conscious about
it.
Or we will verify the date so that we can.
Yes, you. Let it come on 28 November.
In Monday, below.
After that, I may not have time.
I am obliged.
Next.
Item number 32.
Yeah, please, Madhu. This appeal is referred against the judgment and order passed by Honorable Single Judge
on 5/8/2019.
Who appears for the government?
My lord, I am appearing for all the respondents, my lord, Soil Conservation Department. And in this case, my lord, we are led by Mr. Devojit Soitia, my lord, AZ. He's on list. Let him start, my lord, my lord.
The appellant was serving as a stenographer in the office of the
No, this is a different matter.
sorry.
Therefore, I was little surprised. Mr. Chulkul appeared.
Sorry, if I'm Mr. Malik.
27.
No, 27 has gone. We are at 32. 32. Hearing matter.
You be in the.
I'm not there now. Earlier, maybe I was there.
Earlier, your name was there.
Yes.
R. Barua is there.
He is not present. Let the matter come after 2015.
Next. I has come. Because today we have a full bench, so at 2 o'clock,
My lord.
we won't be able to take up.
Yes.
Item number 27 to 29.
My lord, my submission is, if your lordship would kindly take the PIL paper book, I'll rely on that. There are individual petitions also. If your lordship would kindly take the PIL, my lord, page 45.
Yes.
This is the rule, my lord, which has been put to challenge. If your lordship would kindly come to page 45, rule 2, amendment of rule 5. In rule 5 of the Mizoram selection of candidates for higher technical courses rules 2016, sub-rule 1 shall be substituted by the following, namely, all applicants shall be classified as follows for the purpose of allotment of seats. Open category A, B, children of local permanent scheduled tribe, that is ST Mizo residents of the state of Mizoram as category 1. Children of other local permanent scheduled tribe, non-Mizo resident of the state of Assam, Mizoram as category 2. Children of other non-ST tribe, non-ST permanent resident of the state of Mizoram, and children of parents who are serving under the government of Mizoram autonomous bodies as category 3. Children of central and other state government employees not permanently staying in Mizoram as category 4. So these are the 4 categories which they have made, my lord. Then my lord will kindly come to the next page. Explanation. For the purpose of the sub-rule, the term open category shall include candidates belonging to any of the scheduled tribe ST of Mizoram who have been permanently residing in the state of Mizoram, provided that to be eligible for consideration under open category, the candidates who have passed class 11, 12 from any schools within Mizoram state recognized by the government of Mizoram. The term Mizo shall mean those who are non-Jo ethnic indigenous people of the state of Mizoram and have been residing permanently in the state, and the term non-Mizo shall mean non-Jo ethnic scheduled tribe people of the state of Mizoram and have been residing permanently in the state. Now, sub-rule 2 shall be substituted by the following, namely, percentage of seat allocation shall be 4% for open category, 93% for category 1, 1% for category 2, 1% for category 3, and 1% for category 4. If 1% is less than 1, then in such case, it will be rounded up as 1. Provided that to be eligible for consideration under category 2 and 3, the candidates should have passed class 11 and 12 from any school within the Mizoram state recognized by the government of Mizoram. Provided further that to be eligible for consideration under category 4, Either of the parents, whoever is serving, should have been posted in the Mizoram continuously at least for the last 3 years, and the candidates should have passed class 11 and 12 from any school within Mizoram state recognized by the government of Mizoram. So, my lord, effectively what the state has done, my lord, the scheduled tribe order for the state of Mizoram has been in effect amended by state government, which is not permissible. There is nothing like, my lord, geo-ethnic or non-geo-ethnic. If one is scheduled tribe within the meaning of the scheduled tribe orders for the state of Mizoram, then therefore all intent and purpose, they're scheduled tribe. If anything is to be done, it is to be done by the parliament and the central government. It cannot be done tinkered by the state of Mizoram, my lord. They have no power under the constitution. Now, my lord, what had happened, a similar provision was struck down by this honorable court, my lord. That judgment I'll place, my lord. If the judgment starts at page 60, I'll have your lordship's kind attention to page 64 first, my lord. The provision in the earlier rule which was struck down. All applicants shall be classified into 3 categories for the purpose of allotment of seats. Children of permanent resident of the state of Mizoram as category 1. Children of other permanent resident of the state of Mizoram as category 2. Children of central other state government employees not permanently serving in Mizoram as category 3. For the purpose of this sub-rule, the term permanent resident means those who are geo-ethnic people of the state of Mizoram and have been residing permanently in the state. The term other permanent resident means those who are children of non-geo-ethnic people of the state of Mizoram and have been residing permanently in this state. Children of parents who are serving under the government of Mizoram or government corporation or autonomous bodies under the state government who are regular employees of such organization and in whose case it can safely be inferred they would be reside permanently in the Mizoram, including children of deceased employees of the state government whose families are living in Mizoram. Then my lord will kindly skip over to the next page, my lord. To be eligible to be considered for under category 3, either of the parents of candidates should have been residing and posted in the Mizoram for at least 3 years. Percentage of seats for category 1, 2, and 3 are 95% of the total seats shall be reserved for category 1, 4% of the total seats were reserved for category 2, and 1% of the total seats shall be reserved for category 3. So similar provision, my lord. My lord, we kindly come to page 71, the findings of this honorable court in the earlier round, 71, para 19. In view of the above discussion, we are of the opinion that the impugn rule placing children of non-geo-ethnic people of state of Mizoram in category 2 cannot be sustained. It is further observed that they have to be placed along with geo-ethnic people of the state of Mizoram. Correspondingly, liberty is granted to the state of Mizoram to refix the percentage of seats to be reserved for categories of candidates, as finding mentioned in Rule 5. So, my lord, on an earlier occasion, perimeter provision was struck down by this honorable court. Now, my lord, the amendment which I have read, they have again reintroduced the same rule which was earlier struck down. My lord, against the order of the division bench, my lord, an SLP was preferred at page 73, SLP was dismissed. Then a review was filed, review was also dismissed. Now, my lord, this time they have added one more condition. If your lordship would kindly turn back to 40, page number, my lord, 45 once, or rather 46, my lord. Yes. Now, from sub-rule 2, lordships will find that requirement of studying or having class 11 and 12 from any school of the Mizoram is prescribed only in respect of category 2, 3, and 4, not in respect of category 1. How this is permissible, my lord? The requirement of passive studying in class 11 and 12 in the state of Mizoram, this is not prescribed for geo-ethnic. It is prescribed for non-geo-ethnic and children of government employees who are permanently residing in the state of Mizoram.
So in your case is that if a student is belongs to low ethnic.
No, we are non-Zoethnic.
No.
We are Sakmas, my lord.
If a student belongs to that category,
Yes,
even if he has not studied in Mizoram, he will get.
he'll get it.
That is the
That
rule
is-
to understand it.
Yes.
Then we'll have to fix this matter and hear you.
So, my lord, my humble submission was,
We'll do it as fast as possible.
well, since it is an education-related matter,
Therefore, we are giving priority. Otherwise, you
if your
know,
lordship should kindly have it on, Tuesday is a holiday, Wednesday, my. Since it is academic matter, that's why I'm making this request, my lord.
no, that is why we are endeavoring.
Yes.
Let it come on 14th.
Of course, lordship just passed that the admission will be subject to outcome of this
Yes,
case.
we know that.
Lordship, what has happened is that like latest status is that already the seats have been allotted, all the seats. And Lordship admissions, Lordship, no,
That happened in
October,
earlier also.
October
No,
18th.
it appeared in earlier round also.
Yes,
Yes, Lordship. Then Lordship, the counseling
and
has been
content
done.
is pending.
No,
In spite
Lordship.
of direction, they did not consider.
No, Lordship, no seats have been cancelled, the seats have been allotted and like no seats have been cancelled.
That you can argue, we know that position. Everywhere in, this is pan India, either one way or the other.
Yes,
So no, what I'm submitting is that like Lordship, as of now, no seat is vacant, all seats have been allotted. That's it.
no, then in that case, if I succeed, then the last person will have to make room.
That is right.
Yes.
We'll see.
Yes, lordship will mold the relief. Oh. Classes have not started, so. And my lord, even otherwise on the result of the need, my lord, I am entitled. Sorry, the petitioners are entitled. There are, my lord, once again. There are, my lord, one petitioner, Momita Dewan. She secured 30 rank, my lord, in the among the state quota. She secured 334 in the exam. Then there is another candidate, Ranki Tongshaya. She got 291, 60 rank. And total seats are, my lord, 90. 90 seats are there, state quota is 70. There are in all, my lord, 1, 2, 3, 4, 5. At least two must, and this Monita Dewan, my lord, Chakma, there was a direction last time also. See, 1 year she has already lost.
Chaudhary, what Bharat and I were thinking that because it is made subject to outcome of this.
Yes.
We may hear and estimate because even if we hear you on 14th, judgment it cannot be delivered within a period of 1 or 2 days. We'll be faster because it is student matter.
Fine.
Then those who are affected will have to be made party.
Yes.
Because if the room has to be made, because they'll have to be.
That's right.
Because it may not be a fait accompli for all of us.
Then, my lord, let them give the 5 candidates who are down below. We'll implement them.
That is why
Let them give, my lord, we'll implement them. And lordship will have it on 14. We'll do something. We'll serve the copy upon the director of medical education. To them, lordships will affect this.
Mr. Kalita, you give the
Last 5 names.
That can be.
then Mr. Chaudhary, we do one thing.
My lord.
We keep it on 9 for that purpose because then notice will go and it
Yes.
the light of the day. Let
Yes.
it come on 9
Yes.
for that limited purpose.
I'll request my learned friend to give me by Monday, my lord, so that I can make them
That-
participate. Monday.
Let the joint request 9.
Only understanding is, my lord, my learned friend will give the list of the 5% from
From the below.
below.
Because on 12th, there is some
Deep level.
so we do it on 9 because
Not a.
and for both Mr. Chaudhary and Mr. 14th we are saying, but if there is any difficulty, I have to go out somewhere for administrative work. Then I will have 1 day more instead of 14th, 15th.
My lord.
Not later than that.
Yes. Deep level.
Lots.
Because they are student matters, let us decide whatever
Yes,
we
ma'am.
need.
Yes.
One way or the other. I am not recording anything, Mr. Kalita.
Lots.
It is understood that you will give names. of
Yes, yes,
five.
absolutely. I
Matter number 34.
This is your matter. Are you ready?
Lordship, that's what I want to pray before a lordship.
Are you
1
ready
week
or
time
you are
may,
not?
no lordship, 1 week time may kindly be granted.
At the request of Ms. Bhattacharya, give some time. Not exactly. Next.
So number 38 to 40.
May it please your lordship, my lord. As per your lordship, last order dated 1910, the matter was referred to the mediator at Divigor. It appears from the record, no report has come.
So it is a report is awaited.
Awaited.
Mediation is still going on. Council.
Still good, yes. So another date,
As per the earlier order dated 4/11/2022 and 19/10/2022. The mediation proceedings are still being undertaken. The report is awaited. Adjourned to 22nd of November. Any headway, council?
yes, well, there was some discussion was going on the last occasion. Day before yesterday, there was some meeting was decided. But due to some difficulty, the conciliator could not sit.
Oh.
That's why.
Arrive at some solution, so we put an end to this control.
Yes. Obliged. Obliged. Wait, let's go.
Can you?
Matter number 1, 2, and 3.
May it please your lordship. This matter was referred before the larger bench by the division bench on the ground that earlier 3 division bench judgments have been deferred by the earlier division bench of the Honorable Court. So it has been referred to the larger bench. There were 3 judgments of earlier judgments of the division bench, which has said that it is with regard to family pension. And the matter here is basically with regard to the family pension to the other wives other than the senior most wife, basically. The issue was decided earlier by this Honorable Court. And then, your lordship, the senior most wife filed a writ petition wherein I was given the pension. I was given the pension by the authorities because I lived with the deceased at the time of his death, and I was legally married wife. The first wife was living separately, and she was given, your lordship, some, I think, an amount was given to her. Maintenance amount was given to her. When I was given the family pension, then she came before the Honorable Court by filing the writ petition. And in the writ petition, the Honorable Single Judge held that I am being the second wife, I am not entitled to the pension. And the pension should be given to the first wife or the senior most wife. And then, your lordship, this matter came up that in that single bench matter, one judgment of the Honorable Supreme Court was taken into consideration by the Honorable Single Judge. And then on the basis of that, this order was passed. Then I filed the appeal before the division bench, wherein I relied on the judgment of the division bench of this Honorable Court, which was in 2011 for GLT 751. And then, your lordship, this court heard for many dates with the matter, and then ultimately it was found that it differs with a point that section 143 of the Pension Act, and therefore it
place the matter before the larger bench. This is basically the facts of the case, Your Lordship. And then, Your Lordship, the other two judgments that I was referring to of the division bench are also, interestingly, the third judgment that I referred was the writ appeal number 178 of 2020. In fact, that division bench, the honorable single judge who actually allowed the petition, writ petition, was also presiding in that bench, and that honorable single judge has allowed the petition in that case. But in this case, it was rejected. So that is the issue, Your Lordship. In fact, Your Lordship, in the writ appeal, I made a compilation of my submissions and the citations. I in fact filed that. I think that is there in the, but there in fact, one issue was also taken up, that when there is a difference of opinion between two division benches, the matter should go to a larger bench. So judgments to that regard, I have also placed, Your Lordship. So that part, Your Lordship, at this in the larger bench, Your Lordship may not take into consideration. Other than that, I have given the facts and a compilation of my grounds, as well as the judgments which I would like to refer in the matter with regard to giving pension to the wives who are legally married. It is not with regard to void marriages, because here, Your Lordship, the issue is with regard to the Muslim law, and it's a legally married wife. Therefore, she is also entitled. That is basically the point to be taken into consideration.
Do you wish to ask you anything else than the citation, the compilation which you have?
That Lordship, citations I have mentioned, but I have not given the copies.
Copies you need not, because we'll be able to take up. You turn to page 65 of the page.
65.
Yes. Here you have given the factual matrix, and then at page 68, submission of citation before the honorable division.
Yes, Your Lordship, this was filed by me. And grounds were also given, Your Lordship. Then, Your Lordship, the citations were provided. And these citations, actually, this issue was taken up because that the honorable division bench earlier was not in agreement and was thinking of giving it, making it.
Now, if you turn to page 76, that has gone now. You are before
Page
73.
73.
With regard to rule of per inquirium, that we have to, that is not the question now.
No, not at all, because that was taken up in by the division bench. So I have, so Your Lordship, if Your Lordship wants, I would like to actually make a more constructive citations and the submission, and then provide it, because this will not be applicable in the larger bench. So if Your Lordship, if it's convenient to Your Lordship, can then have another day for hearing, and in the meantime, I'll file that along with the Your Lordship judgment and everything.
No, what we were thinking was that the issue is
yes,
that as per the pension rule,
Lordship,
who is entitled to family pension?
Yes.
In the factual scenario, that there are more than one wife.
Yes.
That is the core question.
Yes, Lordship.
Reference order plus what is actually referred to it by the division bench to the largest.
Lordship.
Now, you appear for the appellant.
I appear for the appellant.
Who else is appearing for the other side?
My learned friend is appearing for the writ petitioner.
Writ petitioner, Mr. Bogay. Right, yeah. And Chaudhary Saab for the central
The state is in fact supporting my case in the writ petition.
This is from C8. Same. Because what is referred is the issue. Whatever conclusion we arrive will depend on the core issue which we are propounding. Therefore, one way of looking at it is that this is a pure question.
No.
So all of you can submit written argument.
Lordship, I am appearing for respondent number 4.
All.
Actually, two judgment behind me, actually. Two competent civil court judgment behind me. I have been already declared as legally married wife. Actually, their contention is not right.
Therefore, you can.
Two competent civil court already decided and they had contested.
No, he is not in my case.
So
He
far,
is not in-
601 is concerned. I am 601.
Therefore, all of you submit written arguments. We'll consider and
Yes, that is the best way.
that because argument is only limited to this aspect.
Yeah, absolutely. The only thing is whether legally married wife is entitled. Second wife, yes,
Second.
legally married, because in the other, with regard to some other, your lordship court, with regard to Bombay High Court matter also, I have referred to that. It's a full bench matter. It's lordship. Yes,
Am I audible?
yes, yeah, lordship is audible.
Says that in cases where there are two or more widows, pension will be payable. The word is payable.
Exactly.
And you are arguing on entitled.
Yes.
There's a difference between to whom it will be paid and who all are entitled.
Yeah.
Rule,
I was
in the absence of any challenge to the rule says that the pension department will pay this amount to the first widow.
Yes.
It nowhere provides that she alone is the person entitled to the exclusion of others.
Look.
And she will not use it only for her own purpose.
Yes.
That is not there. So your argument is entitled. So
Entitlement,
even if you are entitled,
Look.
how does it make a difference that payable unless the rules are challenged?
that is true, you know, but the
So
question,
that is
that is, the first question will arise.
No, because Manan,
Yes,
we are not here to examine actually your interstatus.
Got
What decision is to be given is that government is supposed to pay to whom under Rule 140.
Got
That is what probably my brother wants to
Yes,
convey it in
exactly.
a different manner. Therefore, your written arguments also, all of you,
Yes.
should be restricted to only this entitlement. We are not here to decide. We are not civil court.
Got
An occasion may arise that both the wives may have to go to a civil court and say that I am entitled. Government, whether we have to examine whether government is bound to distribute, because pension cannot be distributed. It's a family pension.
the, just if your lordship permit, what has happened till date, your lord, normally after that judgment of 2011 by the division bench of this honorable court, this was followed, your lord, all throughout. And then subsequently two other division benches have again issued the same.
Therefore, we will.
Yes, that is why, your lordship, we have come.
No, my brother is making it clear and
Lord.
rightly so.
Yes,
We are concerned with interpretation of Rule 143. Let us be very
Exactly.
clear.
Yes.
No, nothing like entitlement.
yes,
Equally weighted wife or weighted wife, we are not here to examine that.
lord. Will, I'll
Payable
file,
to whom?
I'll file the written argument.
Mr. Mannan,
Look.
suppose
Hmm.
it's paid to, suppose there is only one wife.
Yes,
It is paid to the wife. There are children who are also entitled to the benefit of the pension. One of the children is not properly looked after, not given. Is it a remedy under 143 that a pension, a part of the pension will also be given to that children separately?
that 143 doesn't speak of.
Then same will be the case of a second wife.
That is,
Entitlement and to whom it will be paid actually
And Mr. Manan,
Lord.
one aspect more. Of course, the judgment does not speak of it anything. Otherwise, when pension papers are submitted
Lord.
on the eve of retirement,
Lord.
one has to mention who is the recipient as a
That-
nominee.
Yes, here it is your lordship, I am the nominee in that paper.
And therefore, it may vary on fact.
Lord,
I have myself passed through that procedure very recently, therefore I know as a matter of fact.
Lord.
One has to state, a joint photograph is to be mentioned. Everything is so, in general, Rule 143 will prevail.
In the pension papers, as per the record, my name was given as well as the photograph. Because the earlier wife has been Lord.
Hold on. We'll file it in again. We'll file the written argument within a week, Lordship. Lord. Within a week, we'll file it. Yeah. Okay.
2019, passed in PIL 62 of 19.
Number 1, my lord.
Look. Here, I am led by Lanet AG. Lanet AG, because of some difficulty, he is not present in the court now. And otherwise, on the other day,
My lord, we have received the document, my lord. We'll file it by Monday. My lord, my sincere apology, my lord. We have received all the document instruction. I was having high fever, so I could not file it, my lord. My lord.
If kindly take up on 17th on Thursday. From 8 to 15, Lanet AG will not be available. Pardon, madam. I'll apply. I'll apply. Lordship, 17th, 18th is a Thursday. Oh, sorry, 17th is a Thursday. Lordship is indicating 80, okay.
Come on. My lord. My lord.